Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or alternative dispute resolution (ADR) in a bid to attract more users to settle their disputes or conflicts with these alternatives: mediation, arbitration, negotiation, conciliation, and early neutral evaluation. My name is DrChinweEgbunike, postdoctoral fellow at the University of Brighton, United Kingdom, and the fellow of the American Bar Association section of dispute resolution. I am excited to welcome Mr. Kehinde Aina to the EVER show. He is the founder of the Multi-Door Courthouse in Nigeria. Precisely, he founded the Lagos Multi-Door Courthouse, LMDC, the first Court-Connected ADR Centre in Africa. Thereafter, he saw its replication in almost 20 state courts, established the Court of Appeal Mediation Centre and the Supreme Court Mediation Centre in Nigeria. As a lead partner in one of Africa's leading law firms, Aina Blankson, he is known for his professionalism, competence, and visionary leadership. Mr. Kehinde wears many hats, so I've left the link to his profile below. Welcome to the show. Let me stop sharing now. Such an honor to have you on the show, sir.
Thank you, Chinwe. It's a pleasure.
Thank you. So without wasting your time, so the first question is, what led to the birth of the LMDC?
I think it's a combination of frustration and the need for change. Frustration on the side of the practice of law, especially on the litigation track, and the delay which that was bringing about in Nigeria. Many years ago, about 20 years ago, it was taking such a long time, and the level of adjournments were quite a whole lot in trials in the High Court in Nigeria. And it was my early days in law practice, and I then saw that there was the need for a change and something different that could complement the litigation track. I didn't know what could. I had no clue about mediation or ADR generally back then, and then that led me to some level of research. And in the course of that as well, there was a client that I was representing, and then they requested for mediation to resolve the dispute. Then that put me on inquiry. So it was a combination of all of that that gave birth to what is now known as the Lagos Multi-Door Courthouse.
Thank you so very much. So how far has ADR enhanced access to justice in Nigeria?
I think in terms of awareness, I feel that it is gone a long way. I think in terms of being able to have the acronym ADR becoming part of the legal lexicon in Nigeria, I think that's also something to say. I think the extent of also judges' recognition of what mediation is and understanding much more than anything else the difference between mediation and arbitration. I think it's possible to say that there is some level of success in that regard. Also to the extent that lawyers in themselves can actually suggest mediation to their clients, especially knowing full well that it is not something that they were taught in law school. I think those are wonderful developments as it were. And what difference has it made? I think it's made a lot of difference, a substantial level of difference in terms of access to justice. A whole bunch of cases are now being sent to the Lagos Multi-Door Courthouse. So I think there's a lot to be said in that regard. But that also suggests that it's been able to achieve all that it was intended to, or there's no room for improvement. There is still a lot of areas of growth and areas for absolute penetration, as it were, in terms of improving overall access to justice in Nigeria and in Africa as a whole.
Thank you so very much on that. I also would say that without it has really enhanced access to justice in Nigeria, and of course, researchers like myself, researching on ADR and Lagos Multi-Door Court, that's part of the enhancement as well. So is there any measurable difference or impact on the cost and time frame for settling disputes under ADR compared to litigation?
I don't think it's even comparable at all. I mean, in terms of the time difference it makes. I mean, back in the day, I remember that one of the very first cases that the Lagos Multi-Door Courthouse handled was a matter which had been in court for about 17 years. And the matter was referred to the Lagos Multi-Door Courthouse. It was a matter that was involving the former vice president of Nigeria, one Chief Alex Ekweme. I'm able to disclose his name now because he actually did consent to us being able to use his details at that time. He's late now, but it was a matter in court, like I said, for about 17 years, and it was brought to the Lagos Multi-Door Courthouse. And within a day of mediation, that entire case was resolved. So in response to the question as to what's the difference of time frame, I think it's just not comparable. You have mediation that can get done in 1 day, some in 2 days, but unfortunately, in a number of the cases, even in the multi-door courthouse, it's not getting congested, so to say. But when you compare it to litigation, I think it's just no basis for comparison at all. Mediation holds a great deal of promise when it's handled properly, and when the mediators who are responsible for mediating those cases actually know what to do and how best to go about it. Having said that, this is not to suggest that all cases that are mediated are settled, but when you compare it to time frame wise, mediation is actually faster, it's cheaper, and much more than anything else, it helps to enhance the relationship between the parties.
All right, thank you so very much. So, in regards to workplace conflict or employment relations, are employees or workers aware of ADR options regarding disputes or conflicts that might arise at their workplace?
I believe they are, and I said that they are, but I would not say that that the level of the awareness in terms of employees is as far-reaching as it ought to be. And I think a lot of things are responsible for that level of awareness. For example, the National Industrial Court, which is the primary court responsible for employment disputes to a large extent, also introduced an ADR center within its own confines as well. This is part of the implications of the replication of the Multi-Door Courthouse initiative, because the industrial court followed the same template and then established the ADR center in that regard. Now, with the availability of the ADR center at the industrial court, it became very possible for employers and employees to have a better level of awareness in terms of what mediation is and what ADR as a whole represents. So that's one way to look at it. Another way to also look at it is that a whole lot more needs to be done in terms of the level of awareness of the labor community as a whole when it comes to what mediation is and what mediation can become in that regard. So I think it can be a lot better, but they are surely aware.
Yeah, so it leads to the second question. To what extent are employees encouraged to use it to settle discrimination, bullying, or harassment?
I think it differs from corporate body to corporate body. I don't think one can have a blanket response to that by saying that it is encouraged, but it depends on the attitude, the disposition, and also the thinking of the management of every corporation. Some companies are a whole lot, in tune with it, and they encourage that as well. Some banks, for example, have been introduced an ombudsman initiative within their confines of their operations. Some have also set up ADR centers within the confines of their operations. So that does help to a large extent. So I think it differs. The simple answer to that is it differs from company to company. Some have gone really far on it, and then some have not gone very far at all. But overall, I don't think that it is one area that you will find a sizable number of corporate bodies that have actually put that in place. As for the public sector, I'm not very aware as to what extent they've been able to encourage that within the private sector.
Okay, how about the trade unions? Do you know, or do you think they're generally supportive of the mediation processes?
Again, one of the very first cases that LMDC was involved in was actually a case among a trade association and the bank itself. On some of the staff, I believe they were laid off, if I remember correctly. And they brought the case over to the Lagos Multi-Door Courthouse. Again, that was one of the very exciting success stories when LMDC got started, and that was resolved. So that helped to up the ante as to the promise of LMDC, and also the essence of mediation in itself as a mechanism to resolve disputes. But unfortunately, if you look at matters like what have been going between the federal government and the Association of Staff of Universities for such a long time, and the inability to find some kind of common ground after so very many efforts, it begins to make you wonder to what extent can mediation or arbitration be deployed in order to resolve those kind of cases. So I would not say categorically that there is adequate reference to or recognition of mediation in terms of dealing with trade union cases, to a large extent. But is it promising for it? Undoubtedly it is. Is there a place for mediation on trade union cases? There's a great deal. If you know, in South Africa, that was one area in which they made a lot of progress and great strides have been achieved in terms of using mediation to address trade union disputes.
Okay. All right. So why does the Trade Disputes Act prohibit disputing parties from bringing their grievances directly before any arbitral body without consulting with the Minister of Trade?
I'm not aware that there is a provision within the Trade Disputes Act which says that they cannot directly bring their cases to an arbitral body without consulting with the Minister of Trade. I don't think that such a provision exists, or perhaps my reading has not gotten me to that level of appreciation or understanding that is something that must be done. I believe there are very categorical provisions within the Trade Disputes Act which encourages the reference to mediation in terms of matters to do with trade disputes, as it were. But having said that, there are, of course, a number of areas within the Trade Dispute Act itself that is long overdue for amendment. If you recall that this is a legislation that is well over 40 years old. I think it was in 1976. So things have changed. At that time, there was no talk of LMDC. There was no place for mediation to a large extent. I mean, structured mediation, that is. I mean, mediation, of course, is as old as the African culture in itself. But in terms of being structured, like what you have in LMDC. So I think there are changes that is required within the Trade Dispute Act itself. But as to whether or not people are encouraged or they cannot bring cases to arbitration or to mediation without consultation with the minister, I'm not so sure that is absolutely correct, unless if there is something you may point out to me in that respect.
Okay, there is a Trade Dispute Act of 2004. I think that's where I sort of read about it. Okay, so let me quickly ask about okay, so what is your advice for parties or intending or potential parties that yet to use ADR mechanisms, and also for practitioners that are new to the field?
I think not knowing about the ADR mechanism for a lawyer, it's only going to be lack of knowledge or lack of understanding or lack of awareness would only be at the peril of the person's practice or adequate representation of clients. In today's business community and in today's practice, and also having regard to the reality of the fact that transactions are largely borderless, you really cannot, do without knowledge of mediation or having awareness of mediation. In terms of drafting contracts, the era of having a direct reference or referral to arbitration is long gone. you have usually a tiered approach to dealing with dispute resolution these days, starting from negotiation to mediation before you then start thinking about arbitration at all. So certainly it is only wise for any single lawyer to equip himself or herself with the nuances and the essence, and more importantly, the promise that mediation can provide in terms of full-fledged representation of clients.
All right, thank you so very much. So, final question. The LMDC directors touched on restorative justice. So, can you please summarize how far restorative justice has gone in Nigeria?
Oh wow! I think the management directors and the management of the LMDC will be better equipped in order to address that question on restorative justice as to what they're doing. I'm aware about that initiative, but as you know, I'm not in direct responsibility to the runnings of the LMDC any longer. But in terms of restorative justice as a whole and its place within the community of ADR, there is no doubt whatsoever in my mind as to what restorative justice can do and what difference it can make in terms of criminal justice administration in Nigeria. There are a whole bunch of petty crimes and small-time crimes, and people have been locked away for so long within the prisons in Nigeria, in which restorative justice can make a lot of difference to them. And to a large extent, if you also understand the Nigerian justice system in itself, you will see that for the most part, the place of the victim in terms of crimes are never given contemplation to. It's usually the state that is against the accused person to a large extent. But the victim of the crime is never given consideration to and what can be done in order to sort out the issue between the defendant or the accused person and the victim. And it's on this area that I think restorative justice also does have a great deal of impact, and it's something certainly worthy of consideration and also worthy of encouragement in every way possible. So it's such a wonderful thing that the Lagos Multi-Door Courthouse is already working seriously on this, and I commend the director and the management for this sense of direction.
Yeah, thank you so very much, sir, for taking our time from your busy schedule to come on the show. I truly appreciate it, and it has been educative. You've touched on the bed of ADR. Gave a comprehensive overview on the bed of ADR and how far it has enhanced access to justice. And while touching on ADR and workplace conflict in Nigeria, it has been exciting and educative as well. Thank you so very much. So, thank you to my constant.
Thank you, Chinwe.
Yeah, so to my viewers, thank you so very much for your constant support. Stay tuned, same time for ADR and workplace conflict. All right, bye-bye, sir. Take care.